So thank you everyone today for joining us for this webinar entitled, Does Your Estate Plan Need a Tune-Up? My name is Alina Nuñez, and I am an estate planning and real estate attorney and probate attorney as well. Some of you I've helped with your estate planning. Some of you I've worked with on probate cases or real estate transaction with probate issues. So today we're going to talk a little bit about, does your estate planning need a tune-up, the basic documents that you should have, when you should review them, and the importance of this. I was mentioned before we started recording, I have to jump to a hearing as soon as this is done on a probate matter. And unfortunately, it's been a probate case that's been kind of lingering for a while, and we're trying to get some issues resolved. But again, it shows the importance of making sure you have proper estate planning in place to avoid things like that for your loved ones, because they're the ones that are going to be dealing with these issues when you're no longer here, unfortunately. So I'm going to go ahead, I'm going to share my screen, and we are going to start with our presentation today. So as I mentioned, our presentation is, does your estate planning need a tune-up? And welcome to all of you that are here today or that are watching this video. I appreciate you taking the time, and we're happy to have you here, because having proper estate planning is an important step, not only in securing your future and your future wishes, but also for your loved one as well. Because when we don't plan and we don't leave our documents in order with what our desires are, we leave those decisions in the hands of a court, or unfortunately, sometimes for our loved ones to kind of fight over what mom wanted, what dad wanted, or who has a right to what. So that is extremely important. So when speaking about doing your estate planning is, when should you update your estate planning, or have you even created one? So if you haven't created one, today's the day. Contact us, schedule a consultation, let's sit down and let's discuss what your estate planning should look like. So as you grow older, as your kids grow older, or you start having grandkids, or if you're even a young couple that is starting out their family now, it's always important to have your plans updated and done and make sure that your wishes are met. So before we dive into when you should be updating your current estate plan, let's look at some of the basic documents that you should already have in place. And if you don't, you should contact us. So first one is called the Durable Financial Power of Attorney, or just Durable Power of Attorney. So what this document is you name the individual that you want to manage your finances in the event that you are uninjured or unable to manage them. So this document is used while you're still alive, but you are in a situation where either you don't have the physical capacity, mental capacity to be able to manage your own affairs. So you pick who you want to manage your finances in these types of situations. You're making that decision. You're not leaving it in the hands of a court or the hands of your family members to fight over who should be doing this. So the power is granted in the document, and it's not only useful in a situation of a crisis, but also in a situation where maybe physically you are not here. If you're traveling abroad and certain things need to be taken care of here locally, then the person that you name and you entrust with this power will be able to do that. And keep in mind, it is someone that you're going to entrust with a lot of power and authority on your behalf. So it's very important to, when you make those decisions, you keep that in mind. The next is the Durable Healthcare Power of Attorney, or sometimes we call this a designation of healthcare surrogate. So similar to the power of attorney we just discussed, this one now is for making decisions related to your healthcare. You again appoint the individual that you want to make those medical decisions on your behalf if you are not able to do so. So again, this document is used while you are alive, but in a situation where you can't make decisions for yourself related to your health. Heaven forbid you're in a coma, you're in the middle of a surgery and there's a complication and their doctors need a consent of whether or not to do a blood transfusion or something to that effect. This is the person that you pick, that you are entrusting to be able to make those best decisions for you in case you can't. So that person or that agent you give the instructions and you tell them the kinds of medical treatment you would want, and they need to follow that and have your instructions. Again, if you don't have this in place and you find yourself in a situation of being in a hospital, in a coma or whatnot, especially we've lived it all in the past 2 years with COVID, your family would have to go to the court, open up a process to have someone officially named, and again, leave that decision as up to the court versus you taking control of that and letting it be known that this is who you want to be named as your agent and who you are trusting to make those decisions. That's why it's very important to have that. An advance directive, or a living will, as it's often called. Please don't get that confused with a last will. A lot of people are like, oh, I need a living will. When I explain to them what that is, they're like, oh no, that's not what I want. I want a last will. So an advance directive or a living will is a document that expresses your wishes in the event that you become incapacitated. It allows you to make the decision of whether or not you want to be maintained alive with life-sustaining treatments in a situation where you are in a persistent vegetative state, in a permanent coma, and basically where 2 doctors have determined that there is no way that you can live for yourself. If you do not want to find yourself basically a vegetable in a bed, you're making that decision. You're saying, if it gets to this point as determined by doctors and basically there's no other recourses, I don't want to be maintained alive artificially. I want to let nature take its course, or whatever it is that you believe in, and that you just be given medication to not suffer and be in pain, but you're taking control of that. I don't know if any of you remember, especially in Florida, the Terry Schiavo case. That is a huge example that I use for the importance of having a living will. She was a young lady. She was, I believe, 26, had a heart attack, didn't die, but she was in a persistent vegetative condition for many, many years. She did not have a living will in place. So her husband and her parents battled it out in court all the way up to the Supreme Court of who should have the decision-making rights, because the husband said that she would not have wanted to live that way as a vegetable in a bed. And the parents said that yes, that they were still hopeful that she could recover from this. And at the end of the day, the court did rule in the husband's favor, and she could not, once they disconnected her, she couldn't live. And she passed away peacefully, but unfortunately it was many, many years of legal battle between her husband, her parents, and in the end, everyone was suffering, seeing her in that condition and having to deal with that stress and animosity of the situation. Again, very important why you should make the decision. Don't let that decision be made by someone else or a court, and put your desires down in writing. And that is the purpose of having your estate planning done. So your last will and testament, this is the one where most people are like, okay, this is what I want to do. This is a document, again, when you pass away, simply put, it determines, or you determine, who gets your assets after you pass away. It's your decision and how you want that to be done, including your money, your property. If you have minor children in a will, you can even name who would be their guardian, who would manage their assets until they reach either 18 or a certain age that you can establish. So it's a very important document. As I mentioned before, the living will is very different from the last will and testament. Living will deals with how you want to be treated when you're dying. Has nothing to do with distributing your assets. That's what the last will and testament does. One thing that people don't necessarily understand about a last will is that it does not avoid probate. Even if you have a last will and testament, that document will have to go through a probate process with the court to make sure that it's admitted as a proper will. It was executed properly. It was a valid will. It met all the requirements that the law requires for a valid will. You had, mental capacity when you signed that document, all of that. And you name an executor in your last will and testament, or a personal representative who is the one that's going to be in charge of handling this process with an attorney and making sure that your assets are distributed according to what you left said in your will. So it's very important. If you want to make sure that your house goes to a certain person, or your jewelry goes to this grandchild or daughter or son, that you leave that in writing. Because if you don't, then what happens is the distribution of your assets will go according to what the law says, and it might not be to the individuals that you want it to go to. So again, all of this is about you taking control of how you want your assets distributed to your loved ones once you are no longer here. Okay. So personal property memorandum, that's one of the things you can include in your last will and testament. So how do you want your personal property to be distributed? You can either include it as part of your will, or oftentimes we attach it as a separate memorandum to your will, or we call a codicil. If you decide down the road, you know what, I want to change it, or I want to make some changes, you don't have to totally redo your will. You can attach a separate memorandum. It can include anything from jewelry, pieces of art, anything that's personal property of you. And again, you can specify who you want those items to be distributed to. So now that we talked about our basic estate plannings, because there's other estate planning documents like a revocable living trust, a special needs trust, and things like that. And those are more advanced estate planning documents. These are your basic 4 documents that everyone should have. So how often should you review your plan? A good rule of thumb is about every 3 to 5 years, but definitely, if not within that time frame, it should definitely happen whenever there's a significant life change. So we're going to cover some of those key changes that explains the importance of going back and reviewing your estate planning documents. So one of them is marriage. Did you recently get married? When you had your estate planning documents done, were you single? And now that you're married, you need to provide for provisions regarding your spouse, or if there's anything that's going to change. So definitely marriage is a life change event that requires you to reevaluate and review your estate planning documents. Then we have divorce. So did you end a marriage? When you did your documents, did you get divorced since then? Very important to make sure you have those documents reviewed after divorce, that your ex-spouse is removed from all of those documents, and that you have new provisions in place of how you want your assets distributed, or even your power of attorneys, your living wills, your healthcare surrogate. If you named an ex-spouse as your agent, we need to revise those and remove that person from those documents. Children. So if you have the birth of a child, or an adoption of a child, or a new grandchild, do you want to include them in your documents? And you need to include them in your estate planning. So again, this is another important time where this is definitely a moment to review your estate planning documents, or if you want to, and it happens, to disinherit a child. And we all see it in the movies or whatever. I'm going to write you out of my will. Yeah, that happens. And that would be the way to do it, is to go ahead and amend your last will and testament to have your child removed. Or if heaven forbid, recently had this situation, if one of your children passes away unexpectedly. I had a client that happened to, and I had to redo her estate planning because one of her sons passed. So this is all obviously important changes that requires you to review your documents and make the necessary changes. Big moves. Did you move to another state? We're seeing a lot of people leaving Miami, going to a different part, not so much in a different part of Florida, but even leaving Florida, going to North Carolina or other states. Or vice versa. We have a lot of snowbirds coming down, New Yorkers, people from California moving into Miami. So you need to review your documents and make sure that your estate planning are legally valid with your new state, whether you're coming into Florida from another state or you're leaving Florida. So it's very important, because there are differences in the law that vary from state to state. I personally am only licensed in the state of Florida. I had a friend reach out to me who moved to Arizona, and she said, hey, I want you to do my estate planning. And she also had recently had a child. And I said, look, I suggest that you contact an attorney in that state, because although I can prepare it here according to Florida laws, if heaven forbid something were to happen, I want to make sure it conforms with Arizona state laws. So any types of big moves, definitely a time to reevaluate and take a look at your estate planning documents. Adult children. So when a grandchild becomes an adult, how does your estate plan change? Maybe you did your estate planning and your child was still a minor. He was 16 or she was a teenager, and now they're in their 20s, and now things are going to change. I know a lot of times we'll put provisions that if any minor were to inherit, it goes into a trust. Well, maybe they're not a minor anymore, and you don't want to necessarily have it go to them in a trust, or you want to create a separate trust for them. These are all important times in which they should be reviewed. If at the time you did your estate planning, your child was a teenager, was a minor, and now they're an adult, definitely we need to take a look at that and see how your needs have changed. Unfortunately, death. So if you had a change in circumstances, let's say you named a guardian for your child in your will and your documents, and now that guardian has passed away. Well, you need to then name an alternate guardian. You need to name a new guardian. So these are all, again, circumstances and things that we need to keep into consideration. Or maybe the person you named is someone you don't want anymore to be the guardian of your child. You need to update your wills and your documents, because if heaven forbid you were to pass, whatever your documents say, that is what the court will take into account. So it's very important. Dependents. Not changing in the number of your dependents. So if all of a sudden, let's say you're now caring for an adult that you did not have before, now they've become your dependent. You need to take that into account in your estate planning documents. So if an adult child or a grandchild becomes disabled, for example, you may wish to update your estate planning to protect that individual. Maybe, have they been diagnosed now, where we need to create a special needs trust? Are they been diagnosed autistic? Do we need to establish something for them where we have something in place that doesn't affect them potentially losing out on certain benefits as they get older that they could receive for whatever disability? These are all important factors to keep in mind when reevaluating your estate planning. So large purchases, if you purchase a new home or another large asset, these have significant financial and tax implications, and they need to be addressed in your estate planning, or even if you sold one. Again, these are all times to review your estate planning, make sure you have everything how you want to have it, and that everything is protected. If you acquired something new, that it's included in those estate planning documents, or if you no longer have an asset, that we can go ahead and remove that, and it's no longer part of your documents because you sold it and you no longer have it. On that same note, asset changes. So large increases or decreases in the value of assets, such as investment accounts. If an asset loses value, how does it affect your estate planning? If you've created a trust and you have, this an IRA or other money market type of financial asset going into the trust, was that the best way? Are we cashing out? Are we doing something with that asset and reinvesting it into something else because of the way that the market has affected? So those are all things to keep in mind when reevaluating your estate planning documents. That's why 3 to 5 years is a good rule of thumb to kind of just look things over, make sure it's exactly how you want it. Just take a few minutes and take a look at it and go back. And maybe you forgot, oh, wow, I didn't realize that I had named this person as the executor. Oh no, maybe I don't want them anymore to be the executor of my estate. I would rather name someone else. Going back to that point, trustees, are you wanting to change the trustee that you name and the person that you named as the executor? It's always important to have that. Our relationships change, our family dynamics change. And so long as you are alive, you have a right to make those changes to your estate planning documents to exclude those people that maybe you don't have a relationship with anymore, that you don't want to take into consideration to have such an important and significant role in your estate planning documents, because it is a big responsibility and role that you are providing, that you're giving them to step in and make sure that your wishes are met. Business changes. So if you have a business, you're an entrepreneur and you have your own company, and did you sell the business? Did you now take on a new partner in that business? These are all things to take into consideration, especially if it's someone that you have a partnership with. Well, what happens to the business? Who's involved in the business? If you pass away, do you have your documents in place that gives your partner the right to buy your interest of the business from your surviving heirs? Or who's going to step in? I mean, does your husband or does your wife know anything about your business? In my situation, personally, I'm an attorney. Nobody can just step in and take over my law practice because you need to have a law license. So it's very important. And actually, we are required by the Florida Bar to have a succession plan if something were to happen to us, because of the fact that we do hold such a specialized license. My husband's not an attorney. He would not be able to just step in and go, okay, I'm going to take over Nunez estate law, even though his name is on it, but he can't because he doesn't have the license to. So it's very important when taking into consideration all those things to have your proper estate planning in place. Other circumstances, illness, death, disability of a family member. We've gone through these. Change in your life or long-term care, other important factors. If your spouse receives a large inheritance or a gift, changes in federal or state law covering taxes and investments or inheritance. Right now, we have a federal inheritance tax at a very high level. So estates over $11.5, $11.6 million, that's when inheritance tax start kicking in. That could change and be brought down to a lower amount. So if there are changes in the law like that, you need to sit down and review your estate planning, because although millions sounds like a large estate, your house is your biggest asset. And the way the market is now, an average house can easily have $500,000 to $1 million valuation. Then you add in whatever money you have in your bank accounts and life insurance policies, and you're easily at a $3 million estate value. And if the law if they bring down those, the limits on when inheritance tax starts, and it brings it down to something at 2 or 3 million, then you're potentially exposing yourself or your heirs to inheritance tax. So we got to strategize and see the best way to plan your estate, do your estate planning to address those types of issues. So that is a wrap for today's webinar. I know it's a lot of content. It's just kind of to give you an idea for those that have your estate planning. When was the last time you took a look at those documents? Sit down, take them out, dust them off a little bit. Feel free to schedule a consultation with me. We can sit down and go through it. Maybe they're perfect. Maybe they're exactly how you want them to be and nothing needs to be done. But maybe there are some changes that you want to make and tweak it, or that need to be made because at the time that you made them, your situation is very different than what it is now. So I ask you, please, if that is the case, give us a call. Be happy to sit down and go through this with you. Make sure that you're leaving all of your estate planning documents done correctly and not leaving a headache for your loved ones, making sure they're protected and avoiding as many problems down the road for them when you are no longer here. As I tell my clients, you're already dealing with the difficult situation of grieving the loss of a loved one. On top of that, of having to deal with the situation of fighting in court with those that are still here, just adds to the pain. So keep that in mind, as well as you never know what life brings you and the situations that we deal with. And having to need those power of attorneys, having to need those healthcare surrogates where you find a parent, a spouse, or heaven forbid, a child in a hospital or in a situation like that. It's better to have it and not need it than to need it and not have it. So I want to thank you all for joining us today. Here is my contact information. If you don't already have it, please jot it down. Follow us on our social media. That's where we go ahead and post about webinars that we host, other types of seminars that we host, and giving you important information, as well as we have our YouTube channel with videos that answer frequently asked questions as well, dealing with all of these types of topics. And again, if you want to schedule a consultation, please feel free to reach out. Be happy to sit down, go through your estate planning with you, take a look at it. And if it's good, I'll tell you, hey, it's all good. You don't need to make any changes to it. But if not, now's the time to take care of that address and make sure that you have everything in place. And it's one of those things that once you kind of do it, you're like, all right, it gives you that peace of mind. And just every, so often just kind of review it, make sure everything is still how you want it done and that your wishes are still being met. So I thank you for all that joined us or watching this video. If you have any questions, feel free to reach out to us. And until the next time, I am Alina Nuñez, your real estate attorney, estate planning and probate attorney, helping you protect your greatest assets for yourself and your future generations.